This is a developing situation that has fundamentally shifted the trajectory of the American political landscape within the last hour. We are receiving credible reports indicating that the Department of Justice is preparing to unseal indictments targeting the closest aides and strategic advisors to former President Donald Trump. This is not speculation. This is a significant escalation in the federal investigation that has been operating quietly behind the scenes for months. The legal firewall that has long surrounded the former President E.S. inner sanctum appears to be on the verge of collapsing, marking a historic and potentially volatile moment for the United States. Moments ago, sources familiar with the special counsel's strategy signaled that the window for negotiation has closed. The flurry of activity we have witnessed at the federal courthouse in Washington, D.C. over the past several days, the secret grand jury testimony, the sudden appearance of high-profile defense attorneys, and the tightening of security perimeters was not routine. It was the prelude to this specific moment. We are looking at a scenario where individuals who once held the highest clearances in the land, who sat in the Oval Office and advised on matters of national security and election integrity, are now facing the very real possibility of federal criminal charges. The gravity of this development cannot be overstated. For the American public, this moves the conversation from the realm of political pundits and cable news debates into the stark, unforgiving reality of the federal court system. An indictment is not a conviction, but it is a powerful statement of evidence. It means that a grand jury of American citizens has reviewed the facts presented by prosecutors and determined there is probable cause to believe crimes were committed. When the Department of Justice targets an inner circle, they are rarely looking for low-level procedural errors. They are often building a comprehensive narrative of intent, coordination, and execution. What we are witnessing right now is the culmination of one of the most complex and sensitive investigations in the history of the Justice Department. The urgency we feel in the air today is the realization that the abstract threat of legal peril has solidified into concrete action. As we wait for the official documents to be unsealed, the question is no longer if charges will be filed, but rather who exactly is on that list, what specific statutes have been cited, and how deep into the former president's orbit this legal strike will penetrate. This is breaking news, but it is also history unfolding in real time. To understand how we arrived at this precipice, we have to peel back the layers of what has been a meticulously guarded investigation. For months, the special counsel has operated with a level of discipline that has frustrated leaks but terrified targets. While the public's attention was often diverted by political rallies and social media storms, federal investigators were engaged in the unglamorous, methodical work of forensic accounting, digital recovery, and perhaps most importantly, flipping witnesses. The inner circle is not a monolith. It is a collection of individuals with varying degrees of loyalty and vulnerability. The DOJ knows that the path to the center of any conspiracy often lies through the aides who executed the orders. This strategy, often referred to as a hub-and-spoke investigation, is classic prosecutorial tradecraft, but applying it to a former presidency is unprecedented. The investigators have likely spent hundreds of hours piecing together text messages, call logs, and encrypted communications to reconstruct the timeline of events that led us here. Every meeting, every directive, and every silence has been scrutinized. What has likely terrified those within this circle is not just what the prosecutors know, but what their colleagues may have already told them. In high-stakes federal cases, the prisoner's dilemma becomes a very real psychological weight. The first to speak often gets the best deal, and the silence from the DOJ suggests they have likely secured the cooperation they needed. The atmosphere in Washington today is a strange mix of high tension and hushed anticipation. In the corridors of power, from Capitol Hill to the law firms lining K Street, there's a recognition that the rules of engagement have changed. For decades, there has been an unspoken understanding about the protections afforded to the executive branch and its advisees. By targeting the inner circle, the Department of Justice is sending a clear, unequivocal message. Proximity to power does not grant immunity from the law. This shatters the assumption of invincibility that often permeates the highest levels of government. We must also consider the immediate human impact of these imminent indictments. These are individuals who have been operating under a cloud of suspicion for a long time, racking up millions of dollars in legal fees, watching their professional reputations hang in the balance. The moment an indictment is unsealed, their lives change irrevocably. They transition from subjects or witnesses to defendants. The biometric processing, the surrender to marshals, the arraignment before a judge, these are humiliating, grounding experiences that strip away the veneer of political prestige. It is a stark reminder that the machinery of justice, once activated, is indifferent to titles or past glories. The timing of this escalation is also critical. We are in a volatile political season, and the Department of Justice is acutely aware of the optics. Critics will inevitably paint this as a weaponization of the judicial system, a narrative that has already taken root in large swaths of the electorate. However, the counter-argument from legal scholars and institutionalists is that the DOJ had no choice but to follow the evidence where it led. To stop short because of political sensitivity would, in itself, be a political act. The prosecutors are walking a razor's edge, knowing that their work will be scrutinized not just by appellate judges, but by historians for generations to come. As we analyze the potential charges, we have to look at the broad categories of legal jeopardy that have been discussed in legal circles. We are likely looking at charges related to obstruction of justice, false statements to federal investigators, and potentially conspiracy to defraud the United States. These are dense, complex charges that rely on proving a state of mind. It is not enough to prove that an action was taken. Prosecutors must prove that the inner circle knew what they were doing was wrong and did it anyway. This requirement of corrupt intent is often the highest hurdle in white-collar criminal cases, which suggests that if the DOJ is moving forward, they believe they have smoking gun evidence, perhaps in the form of audio recordings or contemporaneous notes. The ripple effect of today's developments will be felt far beyond the courtroom. This is a stress test for the American constitutional system. We are watching the executive branch of the current government prosecute the lieutenants of the previous administration. While this is a standard feature of functioning democracies, where the rule of law prevails, in a polarized environment, it is a spark in a tinderbox. The reaction from the public, the response from Congress, and the rhetoric from the former president himself will determine whether this moment strengthens our institutions or further erodes trust in them. There is also a significant strategic element to these indictments. By targeting the inner circle, the Department of Justice is effectively dismantling the support structure around the former president. A leader, no matter how charismatic or powerful, relies on a network of operatives to execute their will. When that network is entangled in legal defense, paralyzed by the fear of perjury, and drained of financial resources, the ability to operate politically is severely significantly hampered. This is the chilling effect in its most potent form. Advisors, who might have been willing to push the envelope in the future, will now look at the fate of their predecessors and think twice. What makes this situation even more compelling is the silence of the key players. In the days leading up to this moment, the usual aggressive counter-messaging we expect has been notably subdued. This silence speaks volumes. It suggests that the legal teams representing these aides have realized that this is not a public relations battle anymore. It is a fight for survival. You cannot spin a federal indictment in a court of law. You cannot tweet your way out of a conspiracy charge. The harsh reality of federal procedure is setting in, and it brings with it a solemnity that is rare in modern discourse. Furthermore, we must look at the specific role of the grand jury. These citizens, drawn from the community, have been hearing testimony in secret for months. They have seen the documents that the public has not. They have looked into the eyes of the witnesses. Their decision to vote for indictments is the crucial democratic check in this process. It is not just a prosecutor's decision. It is a validation by a jury of peers that there is sufficient cause to proceed. This effectively punctures the argument that this is solely a top-down bureaucratic attack. It is a process rooted in the citizenry. As the hours unfold, we expect to learn the names of those indicted. Some may be household names, faces we have seen on television defending the administration for years. Others may be the quiet operators, the lawyers and fixers who worked in the shadows. Regardless of their public profile, their inclusion in this indictment signals that they played a pivotal role in the events under investigation. The Department of Justice rarely casts a wide net without being certain of what it has caught. They do not indict to send a message. They indict to secure convictions. The sheer volume of evidence required to reach this point is staggering. We are likely talking about terabytes of data, thousands of pages of transcripts, and a timeline that reconstructs events down to the minute. The level of detail in the upcoming charging documents will likely shock even seasoned observers. We have seen in previous special counsel investigations that the speaking indictment, a charging document that tells a detailed story, is a preferred tool. It allows the government to lay out its narrative clearly and comprehensively before the first opening statement is ever made in court. This development also raises uncomfortable questions about the nature of advice and consent. At what point does legal counsel become criminal conspiracy? At what point does political strategy cross the line into obstruction? These are the lines the DOJ is drawing today. For the legal profession, this is a watershed moment. It serves as a stark warning to attorneys that their license to practice is not a shield against criminal liability if they become active participants in the crimes of their clients. The piercing of the attorney-client privilege, utilizing the crime-fraud exception, has likely been a key tool in this investigation, stripping away the secrecy that usually protects these conversations. As we stare down the barrel of this breaking news, it is crucial to remain focused on the facts. Rumors will fly and misinformation will spread at the speed of light, but the document that matters is the indictment itself. That document is the result of due process. It is the crystallization of the government's case. When it is unsealed, we will not just be reading a list of charges. We will be reading the first chapter of a legal saga that will define the legacy of the Trump administration and the integrity of the Department of Justice for decades. We are entering uncharted territory. Never before has a former president, Meitz's inner circle, been targeted with such sweeping federal force while he remains the dominant figure in his party. The collision of law and politics is total. The implications for the 2024 election are profound, but the implications for the rule of law are existential. If crimes were committed at the highest level and they went unpunished, the system would have failed. If the prosecutions are perceived as unjust, the system breaks. This is the tightrope the country is walking right now. The coming days will be a blur of arraignments, mugshots, and press conferences. But beneath the circus, the slow grinding gears of the federal court system will begin to turn. Discovery will be exchanged. Motions will be filed. Jury selection will eventually begin. This is not a short story. It is a long, arduous epic. And today, with the imminent unsealing of these indictments, the prologue has officially ended. The main event has begun. As the dust settles on the initial shock of this announcement, we must pivot our focus to the long, arduous road that lies ahead. This is where the frenetic energy of breaking news transitions into the slow, grinding reality of the American judicial process. The indictments are merely the opening salvo in a legal battle that will likely consume the better part of the next year, if not longer. We are moving from the court of public opinion, where rhetoric reigns supreme, to the federal courtroom, where the only currency that matters is admissible evidence. In that sterile, wood-paneled environment, there are no rallies, no cable news chyrons, and no spin. There's only the law, the judge, and the jury. For the defendants, the coming weeks will be a stark lesson in isolation. The inner circle, once defined by its cohesion and shared purpose, is now fractured. In federal conspiracy cases, the strategy of a joint defense often crumbles under the weight of self-preservation. We will likely see a scramble for plea deals, a desperate attempt to minimize exposure by trading information. This is the brutal mathematics of federal prosecution. The first to flip gets the lifeline, while the last to hold out often bears the full brunt of the sentencing guidelines. The loyalty that was once prized above all else has now become a dangerous liability. We must also reflect on what this moment says about the fragility of our institutions. The Department of Justice is testing the proposition that the law is truly blind, capable of reaching into the darkest corners of political power without fear or favor. But this test comes with high risks. If the prosecution is perceived as anything less than airtight, if the evidence is seen as flimsy or politically motivated, the damage to public trust will be catastrophic. The burden of proof here is not just legal, it is historical. The prosecutors are not just trying a case, they are writing a chapter of American history that will be studied for centuries. The societal impact of these indictments will be profound and polarizing. Across the country, dinner tables and social media feeds will be divided. For one segment of the population, today marks a long-awaited day of accountability, a validation that no one is above the law. For another, it is seen as a confirmation of a deep state persecution, potentially hardening their resolve and deepening the schism that already divides the nation. This dual reality, where the same set of facts leads to two completely contradictory narratives, is the defining struggle of our time. The court system is designed to find the truth, but in 2024, we are forced to ask, will that truth be accepted? Looking beyond the immediate legal jeopardy, we have to consider the chilling effect this will have on future administrations. Today's actions set a precedent. They send a warning to every future White House counsel, every chief of staff, and every policy advisor. The line between aggressive political maneuvering and criminal conduct has been drawn in sharp relief. While some may argue this hampers the executive branch, others will contend it is a necessary corrective. A reminder that the oath of office is to the Constitution, not to a specific individual. The legacy of this moment will be a more cautious, perhaps more paranoid, Washington. As the legal proceedings commence, the media circus will inevitably attempt to turn this into entertainment. There will be dramatic reenactments, breathless analysis of body language, and endless speculation. But we must remember the human tragedy at the core of this story. These are people who reached the pinnacle of influence, who had the ear of the most powerful man on earth, and who are now watching their lives dismantle in real time. It is a Shakespearean fall from grace, a reminder that ambition, unchecked by ethical guardrails, often leads to ruin. The coming months will require patience from the American public. The wheels of justice turn slowly and deliberately so. There will be motions to dismiss, fights over classified documents, and intricate jury selection processes. There will be days where it seems nothing is happening, followed by moments of explosive revelation. We must resist the urge to demand instant gratification or immediate verdicts. The integrity of the process depends on its thoroughness. To rush this would be to undermine the very justice being sought. Ultimately, this story is not just about Donald Trump or his inner circle. It is about us. It is about the resilience of the American experiment. We are witnessing a stress test of the democratic system unlike any we have seen in our lifetimes. Can the system hold? Can it process the prosecution of political figures without breaking under the strain of partisanship? The answer to that question will define the future of the Republic long after these specific indictments have faded into archives. As night falls on Washington, the lights at the Department of Justice may burn late, but the die is cast. The sealed envelopes are opening. The secrets are spilling out. The protective bubble has burst. We are left now to watch, to wait, and to witness the solemn march of accountability. In the end, history does not care about political parties or polling numbers. It cares about the truth. And as these indictments prove, the truth has a way of surfacing, no matter how deep it is buried or how fiercely it is guarded. The silence of the inner circle has ended. Now the evidence will speak, and its voice will be heard around the world.